which is still damaging the society under the section 302 of the IPC, Indian Penal Code. Sexual harassments, sexual assaults, rapes, until and unless you have a safe working environment. In this episode, we are going to discuss about the case known as Vishaka versus the state of Rajasthan. So in this video, in this episode, we shall discuss about the Vishaka, that who is Vishaka, what is Vishaka, what are all the sections of Indian Penal Code that are included in this case, and who are the people who are included in this case, and we'll be also dealing with the guidelines of Vishaka that were released by the Supreme Court of India. So let's move in. Before going into the topic, we shall first of all discuss about a woman known as Bhanwari Devi. Bhanwari Devi, she is an Indian social worker where she was given the work by the government to stop the child marriages. So due to her efforts towards the child marriage, she had to go under sexual assaults. She had to go under sexual harassments. Okay, she had to go under sexual assaults and sexual assaults and sexual harassments. So due to this, even her husband had to go under the difficult situations where no one could imagine it. But even though she was going under these assaults and harassments, the rapes, even though she was going under it, the people, they were united and they protested and they said that they are behind Bhanwari Devi and they need justice for it. Then the Vishaka, nothing but Vishaka is an NGO. NGO is nothing but non-governmental organization. It filed PIL in the sense public interest litigation. What does it mean? Nothing but the public interest litigation. It protects the opinions, interests of the people. So Vishaka filed PIL in the Supreme Court, okay, and later saying that the petitioner called upon the Supreme Court to frame the guidelines for preventing the sexual harassments at working place. So this was the PIL filed by Vishaka, filed by the non-governmental organization. Then the petitioner said in the Supreme Court, he said that, my lord, according to the article 19(1)(g) of the Indian Constitution, I have the right to carry out occupation, I have the right to carry out profession. Then how can I carry out my right to profession and occupation if there is sexual harassment against me? How can I carry out? Then the Supreme Court in turn replied. It replied that yes, you are absolutely right, because the article 19(1)(g) of the Indian Constitution, it is just a statement. Until and unless you have a safe working environment. It is not only the article 19(1)(g) of the Indian Constitution that we are going to deal with, because there is also another article that is known as Article 21 of the Indian Constitution, which talks about the right to life, which also talks about the right to life. So we are going to deal with Article 19(1)(g) of the Indian Constitution as well as Article 21 of the Indian Constitution. So this was the sentence released by this Supreme Court. Then what is the exact purpose of of going into this Supreme Court? You might ask me that what is the exact purpose? The exact purpose is that because the primary responsibility for ensuring the safety and dignity through the legislation. Then what is the problem here? It's look like everything is solved. Then what is the exact problem? The problem here is that the Constitution of India had given us these some fundamental rights, right? The Constitution of India given us the fundamental rights, but the Parliament, if the Parliament doesn't make the laws in this type of case, if the Parliament doesn't make the laws in this type of case, this will be called as legislative vacuum. Legislative vacuum. Then the Supreme Court replied that if there is a chance of this legislative vacuum, okay, then the courts like Supreme Court, High Court, these courts will make the guidelines and it will give to the people, to the citizens of India. So if the legislative and executive doesn't make their guidelines, it doesn't mean that the people won't get their fundamental rights, okay, because the courts are here for us. The courts are here for us, for the people of India. So in this judgment, the court provided a set of guidelines which are provided for the employers at workplace to prevent the sexual harassment at workplace. So according to the Article 14 of our Indian Constitution, it said that the guidelines which are made by the Supreme Court, they are to be considered as the law. So what are Vishaka guidelines? Vishaka guidelines, what does it deal with? Under Vishaka guidelines, we have definition, preventive steps, criminal proceedings and disciplinary action. Just take a look at it, because a woman, when she undergoes sexual harassments, when she undergoes the situations like physical contact, demand for sexual favors, sexually colored remarks, showing pornography, which is still damaging the society right now, and any other unwelcome physical conduct of sexual nature, then that particular man shall be hung to death, or he should be punished with imprisonment under the section 302 of the IPC, Indian Penal Code. So any other woman who are facing these sexual harassments, sexual assaults, rapes, she had to complain the sexual, the section 354 of the Indian Penal Code, which deals with the outraging of women's modesty by criminal assault. Our India sleeps, it will sleep in peace when there is no other sexual assaults, when there is no other sexual harassments in our country. India will sleep in peace when there is no other sexual assaults, when there is no sexual harassment, when there is no rape cases like Disha case in Hyderabad we have, and we also have the Nirbhaya case. Until then, I will be back with the another case. So just stay tuned to IMBG. Jai Hind.